This is video 5 in a Miami Condo Investing Club series on House Bill 913 Condominium and Cooperative Associations from the 2025 Florida Legislative Session. Topic: Pages 51 through 67 of the comprehensive 92-page House Bill 913 PDF document released by the Florida Legislature. Introduction. Florida is set to implement changes to the state's overarching condo law beginning July 1, 2025. This new legislation, dubbed House Bill 913 or HB 913, aims to assist cash-strapped condo owners to adapt to the changes being implemented as a result of the tragic Surfside condo collapse in June 2021, when nearly 100 people died and a $1 billion settlement was paid out to the families of the victims. The legislation was passed on April 30, 2025, and signed into law by Florida Governor Ron DeSantis on June 23, 2025. In our effort to stay abreast of the latest trends, opportunities, and challenges in the South Florida condo market, we at the Miami Condo Investing Club have obtained a copy of the new legislation, which is available from the Florida Legislature's website as a comprehensive 92-page PDF document. We plan to make a series of videos highlighting the new legislation for educational purposes. All of our videos will feature AI-generated audio based on the voice of Peter Zaleski, the founder of the Miami Condo Investing Club, reading aloud the legislation verbatim. We hope that our videos will provide viewers and listeners alike a convenient way to listen on demand to the revisions while doing other things, including cooking, exercising, or even gardening. Please note, each video will be less than 60 minutes long in order to facilitate distribution on our website of Miami Condo Club, as well as on popular social media networks. It is also worth noting we will do our best to start and stop the videos based on related topics. However, it is possible that the videos at times may jump around from one topic to another. If this happens, please remember our videos are exact readouts of the text of the House Bill 913 PDF document. This video, the fifth in our series, features pages 51 through 67 of the comprehensive 92-page House Bill 913 PDF document. The text was copied directly from the PDF document and pasted into this video file. No editing was made to the text to create this video. To view the text directly, please visit flsenate.gov/session/bill/2025/913 or alternatively laws.flrules.org/2025/175. If you are seeking independent information, critical analysis, or proprietary research about the South Florida condo market, we would encourage you to consider joining the Miami Condo Investing Club. The club's mission is to foster a community that shares real-time, actionable intelligence on the latest real estate trends, emerging opportunities, and trusted service providers throughout South Florida. Whether you are a do-it-yourself DIY condo buyer or a seasoned real estate professional, the club provides invaluable resources, including up-to-date statistics, expert analysis, and access to tailored consulting services. More information on the club is available at Miami Condo Club. We hope you enjoy video 5 in our series on Florida House Bill 913. This is a readout of pages 51 through 67 of the 92-page House Bill 913 PDF document released by the Florida Legislature. Begin. Section 16. Subsections 1 and 3 of Section 718.501 Florida statutes are amended, and paragraph D is added to subsection 2 of that section to read: 718.501 Authority, Responsibility, and Duties of Division of Florida Condominiums, Timeshares, and Mobile Homes. 1. The division may enforce and ensure compliance with this chapter and rules relating to the development, construction, sale, lease, ownership, operation, and management of residential condominium units and complaints. In performing its duties, the division has complete jurisdiction to investigate complaints and enforce compliance with respect to associations that are still under developer control or the control of a bulk assignee or bulk buyer pursuant to Part Roman 7 of this chapter, and complaints against developers, bulk assignees, or bulk buyers involving improper turnover or failure to turnover pursuant to S. 718.301. However, after turnover has occurred, the division has jurisdiction to review records and investigate complaints related only to 1. Procedural aspects and records relating to financial issues, including annual financial reporting under S. 718.11113, assessments for common expenses, fines, and commingling of reserve and operating funds under S. 718.11114, use of debit cards for unintended purposes under S. 718.11115, the annual operating budget and the allocation of reserve funds under S. 718.1122F, financial records under S. 718.11112A11, and any other record necessary to determine the revenues and expenses of the association. 2. Elections, including election and voting requirements under S. 718.1122B and D, recall of board members under S. 718.1122L, electronic voting under S. 718.128, and elections that occur during an emergency under S. 718.12651A. 3. The maintenance of and unit owner access to association records under S. 718.11112. 4. The procedural aspects of meetings, including unit owner meetings, quorums, voting requirements, proxies, board of administration meetings, and budget meetings under S. 718.1122. 5. The disclosure of conflicts of interest under SS. 718.1111A and 718.3027, including limitations contained in S. 718.1113F. 6. The removal of a board director or officer under SS. 718.1111A and 15 and 718.1122P and Q. 7. The procedural completion of structural integrity reserve studies under S. 718.1122G and the milestone inspections under S. 553.8998, completion of repairs required by a milestone inspection under S. 553.899. 9.8. Any written inquiries by unit owners to the association relating to such matters, including written inquiries under S. 718.1122. 10. The requirement for associations to maintain an insurance policy or fidelity bonding for all persons who control or disperse funds of the association under S. 718.11111H. 11. Board member education requirements under S. 718.1122D5. B. 12. Reporting requirements for structural integrity reserve studies under subsection 3 and under S. 718.1122G12. B1. The division may make necessary public or private investigations within or outside this state to determine whether any person has violated this chapter or any rule or order hereunder, to aid in the enforcement of this chapter or to aid in the adoption of rules or forms. 2. The division may submit any official written report, worksheet, or other related paper, or a duly certified copy thereof, compiled, prepared, drafted, or otherwise made by and duly authenticated by a financial examiner or analyst, to be admitted as competent evidence in any hearing in which the financial examiner or analyst is available for cross-examination, and attest under oath that such documents were prepared as a result of an examination or inspection conducted pursuant to this chapter. C. The division may require or permit any person to file a statement in writing, under oath or otherwise, as the division determines, as to the facts and circumstances concerning a matter to be investigated. D. For the purpose of any investigation under this chapter, the division director or any officer or employee designated by the division director may administer oaths or affirmations, subpoena witnesses and compel their attendance, take evidence, and require the production of any matter which is relevant to the investigation, including the existence, description, nature, custody, condition, and location of any books, documents, or other tangible things, and the identity and location of persons having knowledge of relevant facts or any other matter reasonably calculated to lead to the discovery of material evidence. Upon the failure by a person to obey a subpoena or to answer questions propounded by the investigating officer, and upon reasonable notice to all affected persons, the division may apply to the circuit court for an order compelling compliance. Notwithstanding any remedies available to unit owners and associations, if the division has reasonable cause to believe that a violation of any provision of this chapter or related rule has occurred, the division may institute enforcement proceedings in its own name against any developer, bulk assignee, bulk buyer, association, officer, or member of the Board of Administration, or its assignees or agents as follows. 1. The division may permit a person whose conduct or actions may be under investigation to waive formal proceedings and enter into a consent proceeding whereby orders, rules, or letters of censure or warning, whether formal or informal, may be entered against the person. 2. The division may issue an order requiring the developer, bulk assignee, bulk buyer, association, developer designated officer, or developer designated member of the Board of Administration, developer designated assignees or agents, bulk assignee designated assignees or agents, bulk buyer designated assignees or agents, community association manager or community association management firm to cease and desist from the unlawful practice and take such affirmative action as in the judgment of the division carry out the purposes of this chapter. If the division finds that a developer, bulk assignee, bulk buyer, association, officer, or member of the Board of Administration, or its assignees or agents, is violating or is about to violate any provision of this chapter, any rule adopted or order issued by the division, or any written agreement entered into with the division, and presents an immediate danger to the public requiring an immediate final order, it may issue an emergency cease and desist order reciting with particularity the facts underlying such findings. The emergency cease and desist order is effective for 90 days. If the division begins non-emergency cease and desist proceedings, the emergency cease and desist order remains effective until the conclusion of the proceedings under SS 120.569 and 120.57. 3. If a developer, bulk assignee, or bulk buyer fails to pay any restitution determined by the division to be owed, plus any accrued interest at the highest rate permitted by law, within 30 days after expiration of any appellate time period of a final order requiring payment of restitution, or the conclusion of any appeal thereof, whichever is later, the division must bring an action in circuit or county court on behalf of any association, class of unit owners, lessees, or purchasers for restitution, declaratory relief, injunctive relief, or any other available remedy. The division may also temporarily revoke its acceptance of the filing for the developer to which the restitution relates until payment of restitution is made. 4. The division may petition the court for appointment of a receiver or conservator. If appointed, the receiver or conservator may take action to implement the court order to ensure the performance of the order and to remedy any breach thereof, in addition to all other means provided by law for the enforcement of an injunction or temporary restraining order. The circuit court may impound or sequester the property of a party defendant, including books, papers, documents, and related records, and allow the examination and use of the property by the division and a court-appointed receiver or conservator. 5. The division may apply to the circuit court for an order of restitution whereby the defendant in an action brought under subparagraph 4 is ordered to make restitution of those sums shown by the division to have been obtained by the defendant in violation of this chapter. At the option of the court, such restitution is payable to the conservator or receiver appointed under subparagraph 4, or directly to the persons whose funds or assets were obtained in violation of this chapter. 6. The division may impose a civil penalty against a developer, bulk assignee, or bulk buyer or association, or its assignee or agent, for any violation of this chapter or related rule. The division may impose a civil penalty individually against an officer or board member who willfully and knowingly violates this chapter, an adopted rule, or a final order of the division, may order the removal of such individual as an officer or from the Board of Administration, or as an officer of the association, and may prohibit such individual from serving as an officer or on the board of a community association for a period of time. The term willfully and knowingly means that the division informed the officer or board member that his or her action or intended action violates this chapter, a rule adopted under this chapter, or a final order of the division, and that the officer or board member refused to comply with the requirements of this chapter, a rule adopted under this chapter, or a final order of the division. The division, before initiating formal agency action under Chapter 120, must afford the officer or board member an opportunity to voluntarily comply, and an officer or board member who complies within 10 days is not subject to a civil penalty. A penalty may be imposed on the basis of each day of continuing violation, but the penalty for any offense may not exceed $5,000. The division shall adopt, by rule, penalty guidelines applicable to possible violations or to categories of violations of this chapter or rules adopted by the division. The guidelines must specify a meaningful range of civil penalties for each such violation of the statute and rules, and must be based upon the harm caused by the violation, upon the repetition of the violation, and upon such other factors deemed relevant by the division. For example, the division may consider whether the violations were committed by a developer, bulk assignee, or bulk buyer, or owner-controlled association, the size of the association, and other factors. The guidelines must designate the possible mitigating or aggravating circumstances that justify a departure from the range of penalties provided by the rules. It is the legislative intent that minor violations be distinguished from those which endanger the health, safety, or welfare of the condominium residents or other persons, and that such guidelines provide reasonable and meaningful notice to the public of likely penalties that may be imposed for prescribed conduct. This subsection does not limit the ability of the division to informally dispose of administrative actions or complaints by stipulation, agreed settlement, or consent order. All amounts collected shall be deposited with the Chief Financial Officer to the credit of the Division of Florida Condominiums, Timeshares, and Mobile Homes Trust Fund. If a developer, bulk assignee, or bulk buyer fails to pay the civil penalty and the amount deemed to be owed to the association, the division shall issue an order directing that such developer, bulk assignee, or bulk buyer cease and desist from further operation until such time as the civil penalty is paid, or may pursue enforcement of the penalty in a court of competent jurisdiction. If an association fails to pay the civil penalty, the division shall pursue enforcement in a court of competent jurisdiction, and the order imposing the civil penalty or the cease and desist order is not effective until 20 days after the date of such order. Any action commenced by the division shall be brought in the county in which the division has its executive offices or in the county in which the violation occurred. 7. If a unit owner presents the division with proof that the unit owner has requested access to official records in writing by certified mail, and that after 10 days the unit owner again made the same request for access to official records in writing by certified mail, and that more than 10 days has elapsed since the second request, and the association has still failed or refused to provide access to official records as required by this chapter, the division shall issue a subpoena requiring production of the requested records at the location in which the records are kept pursuant to S. 718.112. Upon receipt of the records, the division must provide to the unit owner who is denied access to such records the produced official records without charge. 8. In addition to subparagraph 6, the division may seek the imposition of a civil penalty through the circuit court for any violation for which the division may issue a notice to show cause under paragraph T. The civil penalty shall be at least $500, but no more than $5,000 for each violation. The court may also award to the prevailing party court costs and reasonable attorney fees, and, if the division prevails, may also award reasonable costs of investigation. 9. The division may issue citations and promulgate rules to provide for citation bases and citation procedures in accordance with this paragraph. If the division may prepare and disseminate a prospectus and other information to assist prospective owners, purchasers, lessees, and developers of residential condominiums in assessing the rights, privileges, and duties pertaining thereto. G. The division may adopt rules to administer and enforce this chapter. H. The division shall establish procedures for providing notice to an association and the developer, bulk assignee, or bulk buyer during the period in which the developer, bulk assignee, or bulk buyer controls the association if the division is considering the issuance of a declaratory statement with respect to the declaration of condominium or any related document governing such condominium community. I, the division, shall furnish each association that pays the fees required by paragraph 2 a copy of this chapter, as amended, and the rules adopted thereto on an annual basis. J. The division shall annually provide each association with a summary of declaratory statements and formal legal opinions relating to the operations of condominiums which were rendered by the division during the previous year. K. The division shall provide training and educational programs for condominium association board members and unit owners. The training may, in the division's discretion, include web-based electronic media and live training and seminars in various locations throughout the state. The division may review and approve education and training programs for board members and unit owners offered by providers and shall maintain a current list of approved programs and providers and make such list available to board members and unit owners in a reasonable and cost-effective manner. The division shall provide the division-approved provider with the template certificate for issuance directly to the association's board of directors who have satisfactorily completed the requirements under S. 718.1122d. The division shall adopt rules to implement this section. L. The division shall maintain a toll-free telephone number accessible to condominium unit owners. M. The division shall develop a program to certify both volunteer and paid mediators to provide mediation of condominium disputes. The division shall provide, upon request, a list of such mediators to any association, unit owner, or other participant in alternative dispute resolution proceedings under S. 718.1255 requesting a copy of the list. The division shall include on the list of volunteer mediators only the names of persons who have received at least 20 hours of training in mediation techniques or who have mediated at least 20 disputes. In order to become initially certified by the division, paid mediators must be certified by the Supreme Court to mediate court cases in county or circuit courts. However, the division may adopt, by rule, additional factors for the certification of paid mediators, which must be related to experience, education, or background. Any person initially certified as a paid mediator by the division must, in order to continue to be certified, comply with the factors or requirements adopted by rule. And if a complaint is made, the division must conduct its inquiry with due regard for the interests of the affected parties. Within 30 days after receipt of a complaint, the division shall acknowledge the complaint in writing and notify the complainant whether the complaint is within the jurisdiction of the division and whether additional information is needed by the division from the complainant. The division shall conduct its investigation and, within 90 days after receipt of the original complaint or of timely requested additional information, take action upon the complaint. However, the failure to complete the investigation within 90 days does not prevent the division from continuing the investigation, accepting or considering evidence obtained or received after 90 days, or taking administrative action if reasonable cause exists to believe that a violation of this chapter or a rule has occurred. If an investigation is not completed within the time limits established in this paragraph, the division shall, on a monthly basis, notify the complainant in writing of the status of the investigation. When reporting its action to the complainant, the division shall inform the complainant of any right to a hearing under SS 120.569 and 120.57. The division may adopt rules regarding the submission of a complaint against an association. O condominium association directors, officers, and employees, condominium developers, bulk assignees, bulk buyers, and community association managers, and community association management firms have an ongoing duty to reasonably cooperate with the division in any investigation under this section. The division shall refer to local law enforcement authorities any person whom the division believes has altered, destroyed, concealed, or removed any record, document, or thing required to be kept or maintained by this chapter with the purpose to impair its verity or availability in the department's investigation. The division shall refer to local law enforcement authorities any person whom the division believes has engaged in fraud, theft, embezzlement, or other criminal activity, or when the division has cause to believe that fraud, theft, embezzlement, or other criminal activity has occurred. P. The division director or any officer or employee of the division and the condominium ombudsman or any employee of the office of the condominium ombudsman may attend and observe any meeting of the board of administration or any unit owner meeting, including any meeting of a subcommittee or special committee, which is open to members of the association for the purpose of performing the duties of the division or the office of the condominium ombudsman under this chapter. Q. The division may 1. Contract with agencies in this state or other jurisdictions to perform investigative functions, or 2. Accept grants in aid from any source. R. The division shall cooperate with similar agencies in other jurisdictions to establish uniform filing procedures and forms, public offering statements, advertising standards and rules and common administrative practices. S. The division shall consider notice to a developer, bulk assignee, or bulk buyer to be complete when it is delivered to the address of the developer, bulk assignee, or bulk buyer currently on file with the division. T. In addition to its enforcement authority, the division may issue a notice to show cause, which must provide for a hearing, upon written request, in accordance with Chapter 120. U. If the division receives a complaint regarding access to official records on the association's website or through an application that can be downloaded on a mobile device under S. 718.11112G, the division may request access to the association's website or application and investigate. The division may adopt rules to carry out this paragraph. V. The division shall submit to the governor, the president of the Senate, the Speaker of the House of Representatives, and the chairs of the legislative appropriations committees an annual report that includes, but need not be limited to, the number of training programs provided for condominium association board members and unit owners, the number of complaints received by type, the number and percent of complaints acknowledged in writing within 30 days, and the number and percent of investigations acted upon within 90 days in accordance with paragraph N, and the number of investigations exceeding the 90-day requirement. The annual report must also include an evaluation of the division's core business processes and make recommendations for improvements, including statutory changes. After December 31, 2024, the division must include a list of the associations that have completed the Structural Integrity Reserve Study required under S. 718.1122G. The report shall be submitted by September 30th following the end of the fiscal year. 2D. Each condominium association must create and maintain an online account with the division as required in subsection 3. 3. On or before October 1st, 2025, all condominium associations must create and maintain an online account with the division and provide information requested by the division in an electronic format determined by the division. The division shall adopt rules to implement this subsection. The division may require condominium associations to provide such information no more than once per year, except that the division may require condominium associations to update the contact information in paragraph within 30 days after any change. The division shall provide a condominium association at least a 45-day notice of any requirement to provide any information after the condominium association initially creates an online account. The information that the division may require from condominium associations is limited to a contact information for the association that includes 1. Name of the association, 2. The physical address of the condominium property, 3. Mailing address and county of the association, 4. Email address and telephone number for the association, 5. Name and board title for each member of the association's board, 6. Name and contact information of the association's community association manager or community association management firm, if applicable. 7. The hyperlink or website address of the association's website, if applicable. B. Total number of buildings, and for each building in the association, 1. Total number of stories, including both habitable and uninhabitable stories. 2. Total number of units. 3. Age of each building based on the certificate of occupancy. 4. Any construction commenced within the common elements within the calendar year. See the association's assessments, including the 1. Amount of assessment or special assessment by unit type, including reserves. 2. Purpose of the assessment or special assessment. 3. Name of the financial institution or institutions with which the association maintains accounts. D. A copy of any structural integrity reserve study and any associated materials requested by the Department within 5 business days after such request, in a manner prescribed by the Department. Section 17. Paragraph D of subsection 1 and paragraphs D and E of subsection 2 of section 718.503 Florida statutes are amended to read 718.503 developer disclosure prior to sale, non-developer unit owner disclosure prior to sale, voidability, 1 developer disclosure, D milestone inspection, turnover inspection report, or structural integrity reserve study. If the association is required to have completed a milestone inspection as described in S. 553.899, a turnover inspection report for a turnover inspection performed on or after July 1, 2023, or a structural integrity reserve study, and the association has not completed the milestone inspection, the turnover inspection report, or the structural integrity reserve study, each contract entered into after December 31, 2024, for the sale of a residential unit shall contain in conspicuous type a statement indicating that the association is required to have a milestone inspection, a turnover inspection report, or a structural integrity reserve study, and has not completed such inspection, report, or study as appropriate. If the association is not required to have a milestone inspection as described in S. 553.899 or a structural integrity reserve study, each contract entered into after December 31, 2024, for the sale of a residential unit shall contain in conspicuous type a statement indicating that the association is not required to have a milestone inspection or a structural integrity reserve study as appropriate. If the association has completed a milestone inspection as described in S. 553.899, a turnover inspection report for a turnover inspection performed on or after July 1, 2023, or a structural integrity reserve study, each contract entered into after December 31, 2024, for the sale of a residential unit shall contain in conspicuous type 1. A clause which states, the buyer hereby acknowledges that buyer has been provided a current copy of the inspector prepared summary of the milestone inspection report as described in section 553.899 Florida statutes, if applicable. A copy of the turnover inspection report described in section 718.3014 and Q Florida statutes, if applicable, and a copy of the association's most recent structural integrity reserve study described in sections 718.1326 and 718.1122G Florida statutes, if applicable, more than 15 days, excluding Saturdays, Sundays, and legal holidays, before prior to execution of this contract, and 2. A clause which states, this agreement is voidable by buyer by delivering written notice of the buyer's intention to cancel within 15 days, excluding Saturdays, Sundays, and legal holidays, after the date of execution of this agreement by the buyer and receipt by buyer of a current copy of the inspector prepared summary of the milestone inspection report as described in section 553.899 Florida statutes, if applicable. A copy of the turnover inspection report described in section 718.3014P and Q Florida statutes, if applicable, and a copy of the association's most recent structural integrity reserve study described in sections 718.10326 and 718.1122G Florida statutes, if applicable. Any purported waiver of these voidability rights shall be of no effect. Buyer may extend the time for closing for a period of not more than 15 days, excluding Saturdays, Sundays, and legal holidays, after the buyer receives a current copy of the inspector prepared summary of the milestone inspection report as described in section 553.899 Florida statutes, a copy of the turnover inspection report described in section 718.3014P and Q Florida statutes, or a copy of the association's most recent structural integrity reserve study described in sections 718.1 to 326 and 718.1122G Florida statutes if requested in writing. Buyer's right to void this agreement shall terminate at closing. A contract that does not conform to the requirements of this paragraph is voidable at the option of the purchaser before closing. 2. Non-developer disclosure. D. Each contract entered into after July 1, 1992, for the resale of a residential unit shall contain in conspicuous type either 1. A clause which states, the buyer hereby acknowledges that buyer has been provided a current copy of the Declaration of Condominium, Articles of Incorporation of the Association, Bylaws and Rules of the Association, a copy of the most recent annual financial statement and annual budget, and frequently asked questions and answers document more than 7 days, excluding Saturdays, Sundays, and legal holidays, before prior to execution of this contract, or 2. A clause which states, this agreement is voidable by buyer by delivering written notice of the buyer's intention to cancel within 7 days, excluding Saturdays, Sundays, and legal holidays, after the date of execution of this agreement by the buyer and receipt by buyer of a current copy of the Declaration of Condominium, Articles of Incorporation, Bylaws and Rules of the Association, a copy of the most recent annual financial statement and annual budget, and frequently asked questions and answers document if so requested in writing. Any purported waiver of these voidability rights shall be of no effect. Buyer may extend the time for closing for a period of not more than 7 days, excluding Saturdays, Sundays, and legal holidays, after the buyer receives the declaration, articles of incorporation, bylaws and rules of the association, and a copy of the most recent year-end financial statement and annual budget, and frequently asked questions and answers document if requested in writing. Buyer's right to void this agreement shall terminate at closing. A contract that does not conform to the requirements of this paragraph is voidable at the option of the purchaser before closing. E. If the association is required to have completed a milestone inspection as described in S. 553.899. A turnover inspection report for a turnover inspection performed on or after July 1, 2023, or a structural integrity reserve study, and the association has not completed the milestone inspection, the turnover inspection report, or the structural integrity reserve study, each contract entered into after December 31, 2024, for the sale of a residential unit shall contain in conspicuous type a statement indicating that the association is required to have a milestone inspection, a turnover inspection report, or a structural integrity reserve study, and has not completed such inspection, report, or study as appropriate. If the association is not required to have a milestone inspection as described in S. 553.899 or a structural integrity reserve study, each contract entered into after December 31, 2024, for the sale of a residential unit shall contain in conspicuous type a statement indicating that the association is not required to have a milestone inspection or a structural integrity reserve study as appropriate. If the association has completed a milestone inspection as described in S. 553.899, a turnover inspection report for a turnover inspection performed on or after July 1, 2023, or a structural integrity reserve study, each contract entered into after December 31, 2024, for the resale of a residential unit shall contain in conspicuous type 1. A clause which states, the buyer hereby acknowledges that buyer has been provided a current copy of the inspector-prepared summary of the milestone inspection report as described in Section 553.899 Florida statutes, if applicable. A copy of the turnover inspection report described in Section 718.3014P and Q Florida statutes, if applicable, and a copy of the association's most recent structural integrity reserve study described in sections 718.1326 and 718.1122G Florida statutes, if applicable, more than 7 days, excluding Saturdays, Sundays, and legal holidays, before prior to execution of this contract, and 2. A clause which states, This agreement is voidable by buyer by delivering written notice of the buyer's intention to cancel within 7 days, excluding Saturdays, Sundays, and legal holidays, after the date of execution of this agreement by the buyer and receipt by buyer of a current copy of the inspector-prepared summary of the milestone inspection report as described in Section 553.899 Florida statutes, if applicable. A copy of the turnover inspection report described in Section 718.3014P and Q Florida statutes, if applicable, and a copy of the association's most recent structural integrity reserve study described in Sections 718.10326 and 718.1122G Florida statutes, if applicable. Any purported waiver of these voidability rights shall be of no effect. Buyer may extend the time for closing for a period of not more than 7 days, excluding Saturdays, Sundays, and legal holidays, after the buyer receives a current copy of the inspector-prepared summary of the milestone inspection report as described in Section 553.899 Florida statutes. A copy of the turnover inspection report described in Section 718.3014P and Q Florida statutes, or a copy of the association's most recent structural integrity reserve study described in Sections 718.1326 and 718.1122G Florida statutes, if requested in writing. Buyer's right to void this agreement shall terminate at closing. A contract that does not conform to the requirements of this paragraph is voidable at the option of the purchaser before closing. Section 18. Section 8 of Chapter 2024-244, Laws of Florida, is amended to read. Section 8. Effective January 1, 2026, Paragraph G of subsection 12 of Section 718.111 Florida Statutes, as amended by this Act, is amended to read. 718.111 The Association. 12 Official Records. G1. An association managing a condominium with 25 or more units, which does not contain timeshare units, shall post digital copies of the documents specified in subparagraph 2 on its website or make such documents available through an application that can be downloaded on a mobile device. Unless a shorter period is otherwise required, a document must be made available on the association's website or made available for download through an application on a mobile device within 30 days after the association receives or creates an official record specified in subparagraph 2. A. The association's website or application must be an independent website, application, or web portal wholly owned and operated by the association. Or Roman II, a website, application, or web portal operated by a third-party provider with whom the association owns, leases, rents, or otherwise obtains the right to operate a web page, subpage, web portal, collection of subpages or web portals, or an application which is dedicated to the association's activities and on which required notices, records, and documents may be posted or made available by the association. B. The association's website or application must be accessible through the Internet and must contain a subpage, web portal, or other protected electronic location that is inaccessible to the general public and accessible only to unit owners and employees of the association. C. Upon a unit owner's written request, the association must provide the unit owner with a username and password and access to the protected sections of the association's website or application which contain any notices, records, or documents that must be electronically provided. 2. A current copy of the following documents must be posted in digital format on the association's website or application. A. The recorded declaration of condominium of each condominium operated by the association and each amendment to each declaration. B. The recorded bylaws of the association and each amendment to the bylaws. C. The articles of incorporation of the association or other documents creating the association and each amendment to the articles of incorporation or other documents. The copy posted pursuant to this subparagraph must be a copy of the Articles of Incorporation filed with the Department of State. D. The rules of the association. E. The approved minutes of all Board of Administration meetings over the preceding 12 months. F. The video recording or a hyperlink to the video recording for all meetings of the association the Board of Administration, any committee, and the unit owners, which are conducted by video conference over the preceding 12 months. G. A list of all executory contracts or documents to which the association is a party or under which the association or the unit owners have an obligation or responsibility, and after bidding for the related materials, equipment, or services has closed, a list of bids received by the association within the past year. Summaries of bids for materials, equipment, or services which exceed $500 must be maintained on the website or application for 1 year. In lieu of summaries, complete copies of the bids may be posted. H. The annual budget required by S. 718.1122F and any proposed budget to be considered at the annual meeting. I. The financial report required by subsection 13 and any monthly income or expense statement to be considered at a meeting. J. The certification of each director required by S. 718.1122D4. B. K. All contracts or transactions between the association and any director, officer, corporation, firm, or association that is not an affiliated condominium association or any other entity in which an association director is also a director or officer and financially interested. L. Any contract or document regarding a conflict of interest or possible conflict of interest as provided in SS 468.4335, 468.4362B6, and 718.30273 M. The notice of any unit owner meeting and the agenda for the meeting, as required by S. 718.1122D3, no later than 14 days before the meeting. The notice must be posted in plain view on the front page of the website or application, or on a separate subpage of the website or application labeled Notices, which is conspicuously visible and linked from the front page. The association must also post on its website or application any document to be considered and voted on by the owners during the meeting or any document listed on the agenda at least 7 days before the meeting at which the document or the information within the document will be considered. N. Notice of any board meeting, the agenda, and any other document required for the meeting as required by S. 718.1122C, which must be posted no later than the date required for notice under S. 718.1122C. O. The inspection reports described in SS 553.899 and 718.3014P and any other inspection report relating to a structural or life safety inspection of condominium property. P. The association's most recent structural integrity reserve study, if applicable. Q. Copies of all building permits issued for ongoing or planned construction. R. A copy of all affidavits required by this chapter. 3. The association shall ensure that the information and records described in paragraph C, which are not allowed to be accessible to unit owners, are not posted on the association's website or application. If protected information or information restricted from being accessible to unit owners is included in documents that are required to be posted on the association's website or application, the association shall ensure the information is redacted before posting the documents. Notwithstanding the foregoing, the association or its agent is not liable for disclosing information that is protected or restricted under this paragraph unless such disclosure was made with a knowing or intentional disregard of the protected or restricted nature of such information. 4. The failure of the association to post information required under subparagraph 2 is not in and of itself sufficient to invalidate any action or decision of the association's board or its committees. This concludes the readout of pages 51 through 67 of the comprehensive 92-page Florida House Bill 913 PDF document. To view the text directly, please visit flsenate.gov/sessions/bill/2025/913 or alternatively laws.flrules.org/2025/175. Thanks for watching. For full access to our comprehensive reports, statistical charts, virtual monthly meetings, and exclusive meetup events, we invite you to join the Miami Condo Investing Club at MyMaCondo Club. The club's mission is to foster a community that shares real-time, actionable intelligence on the latest real estate trends, emerging opportunities, and trusted service providers throughout South Florida. Whether you are a do-it-yourself DIY condo buyer or a seasoned real estate professional, the club provides invaluable resources, including up-to-date statistics, expert analysis, and access to tailored consulting services. An added benefit of the club is that members receive discounts on all Miami Condo Correction walking tours. Please visit miamicondoclub.eventbrite.com for a schedule of upcoming tours. To view additional videos, please visit Miami Condo Club. This concludes our video.